Hello everyone and welcome to this video tutorial on attempts. An attempt is where someone tries to commit a crime but it fails. And that might be for a number of reasons. It might be, for example, a bit like this slide. Maybe they've been caught with their hand in the cookie jar, so to speak, so they're caught in the act or they're caught just before they've managed to commit the crime itself. Or it might be that they try to commit the crime, but they've not used enough poison, or they go to shoot someone and they miss. In all of these circumstances, they've tried to commit the crime, but they've not quite managed to complete it. The reason we have a criminal offence of attempts is because it's preventing offenders from attempting the offence a second time and therefore keeping society safer. And also, of course, even though they haven't actually managed to carry out the full offence, they've still tried to do it, which obviously deserves punishment as well because they've still got the intention to do the offence. I've said an attempt is where a person tries to commit an offence, but they fail to complete it. And an example we've got here of an attempt is the case of White. And if you remember, we looked at this case when we were studying causation. It's a case that shows the but-for test. But it's also useful here because if you recall the facts, our defendant didn't like his mum. And he put cyanide in her tea intending to kill her. But if you remember from when we've looked at it before, we discovered that she died of an unrelated heart attack. And it also turned out that he hadn't used enough poison. Even if she'd have drunk it all, it still wouldn't have killed her. So he had tried to commit murder, but he didn't actually kill his mum because she died of a completely unrelated heart attack. However, he was guilty of attempted murder. So you can be guilty of an attempt where you've tried to commit murder, but you haven't quite managed it. The law on attempt is now contained in the Criminal Attempts Act 1981, but it is useful just to be aware that before we had this act, before 1981, the offence of attempts did exist, but it was common law, i.e. the rules on it came from cases. And before we had this act, there were different tests that the judges would use to try and decide how do we work out if someone is guilty of an attempt, have they done enough for us to prosecute them? So some judges used what was called the series of acts tests. And this meant that the defendant had to have done several things before he could be liable for an attempt. So, for example, if I was going to kill Liam, it might be that I need to order the cyanide online, I measure it out, I put it in his lasagna, I hand the lasagna to him. I've done a series of acts there, and therefore I could potentially be liable for an attempt. Another test that some judges used was the last act test, and this was saying that defendants would only be liable for an attempt if they'd done the very last act before the crime. But this was difficult to decide when the last act had been done. So in that example I just gave you, is the last act of attempting murder when I put the poison in the lasagna, or is the last act when I give it to Liam, or is the last act when I watch him actually taking a forkful of it? So that was problematic. There was also the Rubicon test, which some judges used. And what these judges were saying was that the defendant had to, and it's an old-fashioned phrase, cross the Rubicon and burned his boats, which meant the defendant had to have crossed the line where there was no chance of going back. And again, that was difficult to prove. It could be very late in some situations. So to go back to the lasagna example, with the Rubicon test, have I crossed the line when I've put it in his lasagna? Or have I crossed the line when I've given him the plate? Have I crossed the line when he's taken the first forkful? Because in theory, I could still knock the fork out of his hand at that point if I've changed my mind. So all these tests were a bit problematic in deciding at what point has someone committed an attempt. So the Attempts Act was created in 1981, and it was supposed to try and solve some of those problems and make it clearer at what point will the defendant be guilty of an attempt. Section 1.1 of the Attempts Act says this, quote, if, with intent to commit an offence, a person does an act which is more than merely preparatory to the commission of the offence, he's guilty of attempting to commit the offence. So this is telling us that the mens rea is they have to have the intent to commit the crime that they're trying to commit. And the actus reus is that it must be more than merely preparatory, which means they must have done more than merely prepare. So if I order some cyanide off Amazon, I wouldn't have committed the actus reus of attempts because all I've done by ordering the poison is prepare. Okay, this act is telling us that they have to have gone beyond preparation. And I've just summarised that section with this slide here. So to be guilty of an attempt, section 1.1 is saying they have to intend to commit an offence and they must have done some sort of act which was more than merely preparing to commit the offence. And we'll have a look at some cases which show that actually this new more than merely preparatory test is still a bit problematic. Actus reus of an attempt is that the defendant must have done something that was more than merely preparatory. In the case of Gulliver, our defendant was betting on a dog race and his dog was losing. And he decided he was going to try and get his stake back by jumping onto the track, stopping the race, and then going and insisting that they give him his stake back. Now, he was stopped at the point where he had jumped onto the track, and we decided that he wasn't guilty of attempted theft because he was only preparing at that point. He had stopped the race, but he hadn't actually gone and asked for his money. But what's important for us is that Lane Lord Chief Justice said in this case that the actus reus of an attempt is satisfied when the defendant, quote, embarks upon the crime proper. So what he's saying there is that to be guilty of an attempt, you have to have embarked upon the crime itself. And here at this stage, he just jumped on the track. He hadn't actually asked for his money back, so he hadn't embarked on the crime itself. Now, this is slightly clearer than the more than merely preparatory test. That's what MMP stands for. But it's also a bit annoying that the whole point of the Act was to replace the lots of different common law tests with more than merely preparatory. And now in Gulliver, we've got a new test thrown in the mix that they've embarked upon the crime proper. Boyle and Boyle, our defendants were caught outside a house trying to break in, and they'd broken the hinge on the front door. And they were found guilty of attempted burglary. And using the Gulliver test, it was clear that they'd embarked upon the crime proper, i.e. they'd actually started the crime of burglary because they'd broken the hinge. It was beyond the point of preparation. And I think this case seems fair because they've clearly gone beyond preparing. So that was a fairly clear-cut case. But it's not always going to be as clear-cut as that, as illustrated in the next case of Tosti and White. And here it was similar. The defendants were examining a padlock on a barn, and when they were disturbed, they ran away, and the police discovered cutting equipment in the hedge. And they were held to be guilty of attempting to burgle a barn. The jury found that the defendants' acts were more than merely preparatory. But when you look at what's happened here, in Boyle and Boyle, they'd broken a hinge, whereas here, they were only actually looking at the lock. Now, you might say, well, they only ran away because they were disturbed, but you could also argue, well, they still could have changed their mind. So we do have problems with the more than merely preparatory test. Then got the case of Jones, and here the defendant bought a gun, shortened the barrel, went looking for the victim, found the victim in his car, got into the car, pointed the gun at the victim's head. And the court said here that all of the acts were preparatory, i.e. just preparation, until the point when the defendant got in the car. So I think this is showing that you can actually have to do quite a lot of things before you're actually guilty of an attempt. And this case shows as well that attempts actually require quite a high level of confrontation. Seems a bit bad in a way that the guy actually had to be pointing the gun at the victim's head before he could have been guilty of an attempt, when he's been wandering around the street with this sawn off gun. Up until that point, that wouldn't have been an attempt. So we've then got the case of Campbell, where our defendant planned to rob a post office. He drove to the post office on a motorcycle, walked towards the post office wearing a motorcycle helmet. He had an imitation gun in his pocket and also, very bizarrely, a threatening note, which he was planning to give to the cashier. And he was arrested just before he entered inside the post office. Now, in this case, it was held that the defendant had not embarked on the crime proper, so he wasn't guilty of an attempt, because he'd not actually entered the post office. He'd not got out his imitation gun at that point. They said that they didn't think him wearing his helmet was a disguise, and all of his actions in getting this fake gun, getting this threatening note, were all mere preparation. And again, this, a bit like the case of Jones, is requiring quite a high level of confrontation before you're guilty of an attempt. And really, it looks like the only reason he hadn't entered the the post office was because he was stopped by the police. Had they not stopped him, presumably he would have gone in. So that's a bit problematic as well, because the police then are going to be thinking, do we go and stop people and try and prevent them committing crime? Because if they've not gone quite far enough, we can't have them for an attempt. So it does seem a little bit daft, and he's able to get away with, I would say, quite a lot of things before you're being prosecuted for an attempt. And it's quite clear, I would have thought, by his note and his fake gun, what he was intending to do. We then have the case of Geddes, and this case has been heavily criticised. Our defendant in this case packed himself a rucksack with things like duct tape, a knife, some rope. He actually managed to sneak into a primary school, and he was found hiding in a primary school toilet cubicle with all of this equipment. And it looked like he was trying to kidnap a child. Now, the Court of Appeal ruled that hiding in the children's toilets with all of this kidnapping equipment was just preparation, and that it didn't qualify as more than merely preparatory because he hadn't actually embarked on the crime, he hadn't actually grabbed a child. Now, again, this is showing that we need a high level of confrontation before a person will be guilty of an attempt. The Law Commission have heavily criticised it, and they've pointed out how ridiculous it is that the defendant would have had to have touched a child before he could be convicted of an attempt. But actually, if he had have touched a child or grabbed a child, he would have actually committed the offence of kidnap at that point, so we wouldn't need to have him for an attempt. So this seems like a very strange decision. But it does illustrate the real problem with the more than merely preparatory test. It is possible to attempt the impossible, which sounds very strange, but let's have a look at Section 1, subsection 2. The Act says a person can be guilty of an attempt even if it's not possible for them actually to complete the full offence. Brian, I'm going to skim over quite quickly here because it was overruled in the case of Shivpuri. Here, the person bought a video recorder believing it was stolen when it wasn't, and she wasn't guilty of attempting to handle stolen goods because the House of Lords didn't want to prosecute her for what she thought she was doing rather than what she was actually doing. But as I say, that was overruled in Shivpuri. Here, our defendant was a bit of a hopeless drug dealer because he was dealing what he believed to be cannabis or heroin. He wasn't sure which. But it was actually powdered vegetable matter or cabbage. Now, clearly, he can't actually deal drugs if what he's got is cabbage. It's impossible to drug deal with cabbage. but the court applied Section 1(2) of the Attempts Act and overruled its previous decision in Anderton and Ryan. A defendant can be guilty of attempting the impossible. The final case is Wybrow, that tells us that only intention to kill is enough for attempted